Special provisions for some states. Articles 371 to 371J in Part 21 of the Constitution contain special provisions for 12 states, one viz. Maharashtra, Gujarat, Nagaland, Assam, Manipur, Andhra Pradesh, Telangana, Sikkim, Mizoram, Arunachal Pradesh, Goa and Karnataka. The intention behind them is to meet the aspirations of the people of backward regions of the states, or to protect the cultural and economic interests of the tribal people of the states, or to deal with the disturbed law and order condition in some parts of the states, or to protect the interests of the local people of the states. Originally, the Constitution did not make any special provisions for these states. They have been incorporated by the various subsequent amendments made in the context of reorganization of the states or conferment of statehood on the union territories. Provisions for Maharashtra and Gujarat. Under Article 371, the President is authorized to provide that the Governor of Maharashtra and that of Gujarat would have special responsibility for 2:1. The establishment of separate development boards for I, Vidarbha, Marathwada and the rest of Maharashtra, E, Saurashtra, Kutch and the rest of Gujarat. 2. Making a provision that a report on the working of these boards would be placed every year before the State Legislative Assembly. 3. The equitable allocation of funds for developmental expenditure over the above-mentioned areas. And 4. An equitable arrangement providing adequate facilities for technical education and vocational training, and adequate employment opportunities in the state services in respect of the above-mentioned areas. Provisions for Nagaland. Article 371A makes the following special provisions for Nagaland: 3:1. The Acts of Parliament relating to the following matters would not apply to Nagaland unless the State Legislative Assembly so decides. I. Religious or social practices of the Nagas. E. Naga customary law and procedure. E. Administration of civil and criminal justice involving deceasee according to Naga customary law. And IV. Ownership and transfer of land and its resources. 2. The Governor of Nagaland shall have special responsibility for law and order in the state so long as internal disturbances caused by the hostile Nagas continue. In the discharge of this responsibility, the Governor, after consulting the Council of Ministers, exercises his individual judgment and his decision is final for. This special responsibility of the Governor shall cease when the President so directs. 3. The Governor has to ensure that the money provided by the central government for any specific purpose is included in the demand for a grant relating to that purpose and not in any other demand moved in the State Legislative Assembly. 4. A regional council consisting of 35 members should be established for the Tunsang district of the state. The Governor should make rules for the composition of the council, manner of choosing its members. 5. Their qualifications, term, salaries and allowances. The procedure and conduct of business of the Council. The appointment of officers and staff of the Council and their service conditions. And any other matter relating to the Constitution and proper functioning of the Council. 5. For a period of 10 years from the formation of Nagaland or for such further period as the Governor may specify on the recommendation of the Regional Council, the following provisions would be operative for the Tunsang district. I. The administration of the Tunsang district shall be carried on the Governor. E. The Governor shall in his discretion arrange for equitable distribution of money provided by the centre between Tun district and the rest of Nagaland. E. Any act of Nagaland legislature shall not apply to Tun district unless the Governor so directs on the recommendation of the Regional Council. IV. The Governor can make regulations for the peace, progress, good government of the Tunsang district. Any such regula may repeal or amend an act of Parliament or any other applicable to that district. V. There shall be a minister for Tunsang affairs in the Council of Ministers. He is to be appointed from amongst members representing Tunsang district in the Nagal Legislative Assembly. V. The final decision on all discretion. He is to be appointed from among V. There shall be a minister for Tunsang affairs in the Council of Ministers. He is to be appointed from amongst members representing Tunsang district in the Nagal Legislative Assembly. V. The final decision on all matters relating to Tunsang district be made by the Governor in his discretion. We, members in the Nagaland Legislative Assembly from Tunsang district are not elected directly by the people but by regional council. Provisions for Assam and Manipur. Assam under Article 371b6, the President is empowered to provide for the creation of a committee of the Assam Legislative Assembly consisting of the members elected from the tribal areas of the state and such other members as he may specify. 7. Manipur Article 371c makes the following special provisions for Manipur. 8:1. The President is authorized to provide for the creation of a committee of the Manipur Legislative Assembly consisting of the members elected from the hill areas of the state. 9. 2. The President can also direct that the Governor shall have special responsibility to secure the proper functioning of that committee. 3. The Governor should submit an annual report to the President regarding the administration of the hill areas. 4. The central government can give directions to the state government as to the administration of the hill areas. Provisions for Andhra Pradesh or Telangana. Articles 371d and 371e contain the special provisions for Andhra Pradesh. 10. In 2014, Article 371d has been extended to the state of Telangana by the Andhra Pradesh Reorganization Act of 2014. Under Article 371d, the following are mentioned. 1. The President is empowered to provide for equitable opportunities and facilities for the people belonging to different parts of the state in the matter of public employment and education, and different provisions can be made for various parts of the state. 2. For the above purpose, the President may require the state government to organize civil posts in local cadres for different parts of the state and provide for direct recruitment to posts in any local cadre. He may specify parts of the state which shall be regarded as the local area for admission to any educational institution. He may also specify the extent and manner. For the above purpose, the President may require the state government to organize civil posts in local cadres for different parts of the state and provide for direct recruitment to posts in any local cadre. He may specify parts of the state which shall be regarded as the local area for admission to any educational institution. He may also specify the extent and manner of preference or reservation given in the matter of direct recruitment to posts in any such cadre or admission to any such educational institution. 3. The President may provide for the establishment of an administrative tribunal in the state to deal with certain disputes and grievances relating to appointment, allotment or promotion to civil posts in the state. 11. The tribunal is to function outside the purview of the State High Court. No court, other than the Supreme Court, is to exercise any jurisdiction in respect of any matter subject to the jurisdiction of the tribunal. The President may abolish the tribunal when he is satisfied that its continued existence is not necessary. Article 371e empowers the Parliament to provide for the establishment of a central university in the state of Andhra Pradesh. Provisions for Sikkim. The 36th Constitutional Amendment Act of 1975 made Sikkim a full-fledged state of the Indian Union. It included a new Article 371F containing special provisions with respect to Sikkim. These are as follows. 1. The Sikkim Legislative Assembly is to consist of not less than 30 members. 2. One seat is allotted to Sikkim in the Lok Sabha and Sikkim forms one parliamentary constituency. 3. For the purpose of protecting the rights and interests of the different sections of the Sikkim population, the Parliament is empowered to provide for the number of seats in the Sikkim Legislative Assembly which may be filled by candidates belonging to such sections. And delimitation of the assembly constituencies from which candidate belonging to such sections alone may stand for election to assembly. 4. The Governor shall have special responsibility for peace and for an equitable arrangement for ensuring the social and economic advancement of the different sections of the Sikkim population. In the discharge of this responsibility, the Governor shall act in his discretion, subject to the directions issued by the President. 5. The President can extend, with restrictions or modifications, to Sikkim any law which is in force in a state of the Indian Union. Provisions for Mizoram. Article 371G specifies the following special provisions for Mizoram. 12:1. The Acts of Parliament relating to the following matters would not apply to Mizoram unless the State Legislative Assembly so decides, I. Religious or social practices of the Mizos. E. Mizo customary law and procedure. E. Administration of civil and criminal justice involving Decisi according to Mizo customary law. And IV. Ownership and transfer of land. 2. The Mizoram Legislative Assembly is to consist of not less than 40 members. Provisions for Arunachal Pradesh and Goa. Arunachal Pradesh. Under Article 371H, the following special provisions are made for Arunachal Pradesh 13:1. The Governor of Arunachal Pradesh shall have special responsibility for law and order in the state. In the discharge of this responsibility, the Governor, after consulting the Council of Ministers, exercises his individual judgment and his decision is final. This special responsibility of the Governor shall cease when the President so directs. 2. The Arunachal Pradesh Legislative Assembly is to consist of not less than 30 members. Goa. Article 371I provides that the Goa Legislative Assembly is to consist of not less than 30 members. 14. Provisions for Karnataka. Under Article 371J, the President is empowered to provide that the Governor of Karnataka would have special responsibility for 1. The establishment of a separate development board for Hyderabad Karnataka region 15-2. Making a provision that a report on the working of the board would be placed every year before the State Legislative Assembly. 3. The equitable allocation of funds for developmental expenditure over the region. 4. The reservation of seats in educational and vocational training institutions in the region for students who belong to the region. 5. The reservation in state government posts in the region for persons who belong to the region. Article 371J, which provided for special provisions for the Hyderabad Karnataka region of the state of Karnataka, was inserted in the constitution by the 98th Constitutional Amendment Act of 2012. The special provisions aim to establish an institutional mechanism for equitable allocation of funds to meet the development needs over the region, as well as to enhance human resources and promote employment from the region by providing for local cadres in service and reservation in educational and vocational training institutions. In 2010, the Legislative Assembly as well as the Legislative Council of Karnataka passed separate resolutions seeking special provisions for the Hyderabad Karnataka region of the state of Karnataka. The government of Karnataka also endorsed the need for special provisions for the region. The resolution sought to accelerate development of the most backward region of the state and promote inclusive growth with a view to reducing inter-district and inter-regional disparities in the state. Table 37.1 Articles related to special provisions for some states at a glance. Article number. Subject matter 371. Subject matter 371. Special provision with respect to the states of Maharashtra and Gujarat. 371A. Special provision with respect to the state of Nagaland. 371B. Special provision with respect to the state of Assam. 371C. Special provision to the state of Manipur. 371D. Special provisions with respect to the state of Andhra Pradesh or the state of Telangana. 371E. Establishment of Central University in Andhra Pradesh. 371F. Special provisions with respect to the state of Sikkim. 371G. Special provision with respect to the state of Mizoram. 371H. Special provision with respect to the state of Arunachal Pradesh. 371I. Special provision with respect to the state of Goa. 371J. Special provisions with respect to the state of Karnataka. Notes and references. 1. Part 21 is entitled as Temporary, Transitional and Special Provisions. 2. This article was amended by the 7th Constitutional Amendment Act of 1956 and the Bombay Reorganization Act of 1960. Andhra Pradesh was taken out of this article by the 32nd Constitutional Amendment Act of 1973 and provided for separately in two new articles 371D and 371E. 3. This article was added by the 13th Constitutional Amendment Act of 1962. 4. The validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in the exercise of his individual judgment. 5. The Deputy Commissioner of the Tunsang district shall be the ex officio chairman of the regional council and the vice chairman shall be elected by the members of the council from amongst themselves. 6. This article was added by the 22nd Constitutional Amendment Act of 1969. 7. The tribal areas of Assam are specified in the 6th schedule of the Constitution. They are North Kachar Hills District, Karbi Anglong District and Bodoland Territorial Areas District. 8. This article was added by the 27th Constitutional Amendment Act of 1971. 9. In this article, the expression hill areas means such areas as the President may, by order, declare to be hill areas. 10. Both the articles were added by the 32nd Constitutional Amendment Act of 1973. 11. The tribunal has been set up by the Andhra Pradesh Administrative Tribunal Order, 1975. 12. This article was added by the 53rd Constitutional Amendment Act of 1986. 13. This article was added by the 55th Constitutional Amendment Act of 1986. 14. This article was added by the 56th Constitutional Amendment Act of 1987. 15. The Hyderabad, Karnataka region includes the 6 backward districts of northern Karnataka, viz. Gulbarga, Bidar, Raichur, Koppal, Yadgir and Bellary. Part 5 Local Government.